Hello all, welcome to Legal Talks by Desi Kanun. I am Suyash and I am excited to have started this show. On today's show, we will talk about another judicial pronouncement by the Honorable Supreme Court of India. Its name is Advocate on Record, includes a proprietary firm, etc. An advocate, namely Siddharth Murarka, was involved in this case. The moot question in this case was whether an advocate on record can have entry in advocate on record register in the form of his style of carrying on profession, that is, instead of Siddharth Murarka, as Law Chambers of Siddharth Murarka. The advocate Siddharth Murarka wanted his name and office to be reflected in the registry as Law Chambers of Siddharth Murarka. The registry was not permitting him to use the name Law Chambers of Siddharth Murarka, and in order to resolve this conundrum, the Honorable Supreme Court looked into Order 4 of the Supreme Court Rules of 2013. It perused Rule 13 Sub Rule 1, Rule 22, Rule 23 and Rule 1B. These rules provided that an advocate or two or more advocates on record may enter into partnership with each other, and this partnership must be registered with the registrar of the Honorable Supreme Court. If the partnership of the advocates fulfills these guidelines, then such partnership is recognized under the Supreme Court rules. After perusing these rules, the Supreme Court made three very important observations. Firstly, it said that the Supreme Court is established under Article 124 of the Constitution of India, and the rules of the Supreme Court are framed under the powers conferred by Article 145 of the Constitution of India. These rules owe their history to the Federal Court Act 1941 and the Government of India Act 1935. Secondly, the court observed that if a partnership firm can be registered and operated, it may also be permitted to do so as a sole proprietor. The Supreme Court wanted to say that if such different styles of writing names are to be permitted, then there must be appropriate amendment in the Supreme Court rules to this effect. Thirdly, the court also stated that the expression Law Chambers has a history from England and also in India, because we borrowed a considerable jurisprudence from England, where it is a reference to a particular lawyer in whose chambers people may be carrying on the legal practice. It was further observed that effectively this style only records the practice of the chamber, which is in essence a sole proprietorship. Thus, after making all these observations, the court held that writing Law Chambers of Siddharth Murarka, Sole Proprietor Siddharth Murarka, Advocate on Record, Supreme Court of India, and his AOR number is permissible style of putting on the letterhead and in the Wakalatnama. Hence, the court was of the view that writing Law Chambers of Siddharth Murarka is not a wrong practice, and the court passed appropriate orders in this regard. Now, what are my views on this matter? The issue involved in the present case is a problem that is faced quite often by the advocates. In Indian context, it would not be out of place to say that the functioning of a law office or a law chamber is such that most of the work is being done in the name of one person only, that is, in the name of the person to whom that chamber or office belongs. The juniors or the associates working in a law office or a law chamber often face difficulty before the registry, the clients, and sometimes even before the courts in explaining their locus or their footing or their identity with respect to the office to which they belong. It is also my view that the practice of writing the name of the law chambers would strengthen the role of juniors and associates, who in fact are the backbone of any law office or law chamber. The Honorable Supreme Court in this case emphatically considered the plight of the petitioner and showed a large heart by permitting him to do something as a matter of right, rather than denying the same to him on the ground of procedural technicalities. The court could have very well said that appropriate amendment in the Supreme Court rules need to be carried out in order to permit him to write Law Chambers of Siddharth Murarka, but the court showed a large heart and permitted him. So that is it about this judgment of the Honorable Supreme Court. See you next time. Till then, stay safe, stay tuned, and thank you once again for listening to this show.